respect Please take your seats. Thank you. Caribbean Court of Justice, original jurisdiction. The following four matters, consolidated matters, have been scheduled for a hearing review this morning. They are as follows. Trinidad and Tobago OJ 2018-001 between Trinidad Cement Limited versus the State of Trinidad and Tobago, Rockhard Distributors Limited, Motilal Ramhit and Sons Contracting Limited. Trinidad and Tobago OJ 2018-002 Trinidad Cement Limited versus Arawak Cement Company Limited versus the State of Barbados and Rockhard Cement Limited. St. Lucia OJ 2018-001 between Rockhard Distribution Limited versus the State of Trinidad and Tobago and the Caribbean Community. And the fourth, Barbados OJ 2018-001 Rockhard Cement Limited versus the State of Barbados and the Caribbean Community. Can we have the appearances for the court, please? Thank you.
Good morning, Mr. President, Your Honors. In the consolidated matters, the Trinidad Cement Limited and Arawak Cement Company Limited team has been consolidated. So in both TTOJ01 and 02, Mr. Armour, Senior Counsel, Mr. Peterson, Senior Counsel, leads Mr. Gregory Pantin, myself, Mr. Rafael Ajodia, and we are instructed by Mr. Miguel Vasquez. Thank you.
Leads me tomorrow to see for the State of Trinidad and Tobago. We are instructed by Mr. Brent James and Ms. Rada Supayo, who are the defendant in TTOJ2018-01, contracting party in TTOJ2018-002, and the first defendant in SLUOJ2018-002.
Alan Wood and... May it please your honors, in relation to CCJ application TTOJ2018-002 and BBOJ2018-001, Donna Bassett, who's the entering appearance on behalf of the State of Barbados.
Yes.
May it please you, Alan Wood and Symone Mayhew appear for the Rockhard parties in all the claims.
May it please your honors, I'm Corlita Bab Schiffer, and I appear on behalf of the community in cases number 3 and 4.
Yes, good morning, Council. Today what we had planned to do was to sort of tie up the arrangements for the trial on the 11th of June. We've seen the submissions and the various witness statements and the objections that have been raised. There have been objections about witnesses, about relevance, and we are minded to address those objections at the trial itself, rather than attempt to deal with them here and now. So the course that we are minded to pursue is that we determine the order in which the witnesses will give their evidence, and in which they will be cross-examined. And we are hoping that we will be able to take all the witnesses to have all the cross-examinations done on the first day. If we allot ourselves 6 hours for that day, then we will go through this list shortly to see whether it is possible that we can, on that first day, hear all the witnesses, so that on the second day, we then hear the submissions, which submissions can, and I'm pretty sure will include objections as to relevance and any other submissions which council wish to make. At this stage, we can order that for the time being, all the witness statements that have been filed will stand as evidence in chief, subject to any further decisions as to upholding objections on relevance or anything along those lines. As to the order in which the witnesses will take the stand and be cross-examined, we thought that TCL's Dr. Grayson, that's the only TCL witness who I believe any party wished to cross-examine, that Dr. Grayson will first be cross-examined. He would first be cross-examined by the state of Trinidad and Tobago, followed by Rockhard, followed by CARICOM. Now, what I need to know from the state of Trinidad is how long do you think you wish to take in cross-examining Dr. Grayson?
Your Honor, as if you would recall, we had said we would reserve the right to, so it's not really something that Mrs. Speaker and I discussed before I came here today, but I would probably say no longer than half an hour.
Okay. Mr. Wood, will you cross-examine Mr. Grayson?
May it please you, my lords. I had in fact filed an application to dispense with the taking of further evidence, having regard to the fact that the parties went to great effort to agree a statement of facts and issues. So based on that statement of agreed facts and issues, for myself, I really don't see, if we stick to that, what we need to cross-examine anybody about. This is a matter which turns on, if you take the agreed facts, it turns on the application of the relevant principles. There is disagreement between the parties as to what those principles are, and that is a matter for the court. But I really think that one needs to stand back and look at this matter, having regard to the fact that the parties have gone to efforts to settle an agreed statement of facts and issues. So there is really no issue of fact, as far as I'm concerned, that is in dispute, that is relevant to the determination of these proceedings. And that's why we went to the trouble of filing an application to ask the court to consider the matter, standing back and looking at where we are in this matter. The court may not wish to hear me, but the fact of the matter is the parties have gone to great expense. It is a matter the court has to take into consideration in a just determination of this matter. We had a trial last year, July. Of its own motion, the court reopened the matter. The matter went to the WCO. The WCO was able to look at the rival contentions of the parties, which were even further apart then than they are now, and to come to a determination of the matter. The matter has gone to the Customs Committee. The matter has gone to COTED.
Mr. Wood,
Mr. Wood,
all of that.
We know all that. So we want just to be practical. If you say, I don't want to cross-examine Mr. Grayson because it is to no use, then you say, I don't wish to
Well,
cross-examine him.
I will reserve my right.
Okay.
If we are going to go full hog, I will reserve my right.
Okay. That cross-examination is reserved because, Mr. Wood, from a practical standpoint, you are not going to be any, if your submissions are upheld, and we will not give a decision, we will not adjudicate on that application today. But we would certainly look at it at the time when we
It's not my
at the
submission.
hearing.
There are submissions of all parties. It's a matter of law, and the court is competent to look at the matter and determine the question of law, just like the WCO did.
Mr. Wood, that is your view.
So all of this is
There are other
unnecessary.
counsel who seem to have a different view. And so
So I'm
ultimately,
asking the court to look at it.
just a minute, Mr. Wood, just a minute. Ultimately, the court would have to decide whether it agrees with your view or whether whatever contrary view that exists is one that the court agrees with. But ultimately, you are not going to be prejudiced if the court does not make a decision on your objections. No, I don't see how you can be. The most you can be prejudiced
We
is to
must
say,
be
well,
prejudiced.
that
We
you have
must be
wasted
prejudiced
some
because
time.
it's a question of putting my client to additional costs
Your
to get
Honors,
witnesses together.
Your Honors, this is Reginald
And I
Armour.
have made this
I wish to be
application in good
heard,
time
please.
for the court
Just
to
a minute, one at
consider
a
the
time.
matter.
Okay, Mr. Wood, we've heard you. We've heard you on this issue. And you have a view on it. It's not a view that everybody holds. And since it's not a view that everybody holds, it's a view which has to be adjudicated. It has to be decided. It has to be determined upon. And we are not going to determine the issue now. And the only prejudice you could suffer is as to cost, yes, as to time, yes. But suppose you don't prevail in that view. You see? So let's not go down further on that road, Mr. Wood.
Your Honors, Mr. President, Reginald Armour, I'm at the disadvantage of being present by video link. I hope that Your Honors can hear me.
We are hearing you very clearly. And Mr. Wood
I just
suffers
want
from
to
the same disadvantage.
I just want to put on record, Your Honors, in the context of Mr. Wood's, to use the most neutral term that I can find, insistence on being heard on his application, that we filed a notice responding to that application yesterday. Unfortunately, I understand it was not uploaded until this morning. But from that notice of our response, I just want to put on record that we will certainly, when the court comes to adjudicate on Mr. Wood's application, we will certainly want to be heard. Thank you very much.
Yes. Mrs. Bab Schaefer, you wish to cross-examine Dr. Grayson for how long?
Dr. Barb Schaefer?
Dr. Bab Schaefer, are you hearing us? Ouch. Is it Guyana that we're seeing on the screen? Yeah? She's not hearing us? Okay, shall we call her on her phone? Yeah? Okay.
Dr. Barb Schaefer, can you hear us now?
But we may not be hearing. One way or the other, both sides are not hearing each other.
Your Honors, I wonder if now might be a good time. For the second, on the 5th of April, we had filed a notice, supplemental notice, indicating that we wish to cross-examine Dr. Grayson.
That is Mutilal Ramet.
Yes, please.
And how long would you be? Okay, this is purely timetable, so that I don't think that CARICOM will be prejudiced if we proceed. Trinidad's witnesses, Ms. Kathy Ann Matthews, Mr. Wood, if you have to cross-examine Ms. Matthews, how much time would you need?
I would say 15 minutes. I would say 15 minutes for
Yes.
everybody. It's not that long.
Very well. TCL wished to cross-examine Ms. Weeks and Mr. Bascom.
No, no, my lord.
No?
No, Mr.
No,
President.
no,
We
may
filed an
please.
amended notice
I see.
in which we
Let's start again. 30 plus 25 plus 10 plus 25 plus 10 plus 20 plus 10 plus 15 plus 10 plus 25 plus 25 plus 30 plus 60 plus 15. How much time we have there? About 5 hours. Okay. Well, okay. It suggests that we can conceivably get everybody in on the first day. It would be a long day. We want to start at 9 and go to 12 with a 20-minute break in the middle. If we have an hour at most for lunch, we then go from 1 to 4 with a 20-minute break, or maybe a little after 4, about to 5. So we go from 9 to 5 with lunch and 2 20-minute breaks. And well, that would have to include the re-examination.
And of course, it also includes questions from the bench.
I think it's doable. Mr. President, Mr. President and Your Honors, I was just looking at the affidavit of Ms. Barb Shiva. We had not had an opportunity to consider this, so we also want to reserve our right to look when we look at that affidavit. But another point has occurred to me is that counsel is the deponent of this affidavit, and in the event that there is to be cross-examination of that deponent, I don't know how. I'm just flagging that. I'm not objecting, but I'm just thought it might be a point to consider.
Yes. That would put you in an awkward position, Dr. Bab Schaefer. Is there going to be any objection to Dr. Bab Schaefer being cross-examined on her affidavit, even as she is counsel? In principle, it's not ideal, but does anyone specifically object to it?
May I, Your Honor, Reginald Armour, may I ask for clarification on that question? Is the question whether there is objection to Dr. Bab Schaefer giving evidence since she is counsel, or to cross-examination of Dr. Bab Schaefer?
Well,
I'm not sure.
Well, both. One is already almost a fait accompli. She's sworn an affidavit in the matter, and a couple affidavits, and someone has expressed a desire to cross-examine her. Now, the whole idea is for us to be able to get all of the information that we need to get to make decisions in this matter, and if possible to get the information from the best sources. So in those circumstances, I was asking whether anyone will lodge an objection to her providing the information that she can provide to the court, even though she is counsel.
Well, I think if I may just follow on from Mr. Peterson, we have flagged it. We don't want to take an objection. There is an old common law observation and practice that counsel doesn't give evidence because, in fact, in our code of ethics in Trinidad and Tobago, one is disqualified as counsel from giving evidence because then you deny your client's entitlement to counsel. We flag that. We don't want to take an objection, and it occurs to me, Your Honor, and this relates to another point that I was going to just ask the court to consider. It could be that what we, that is to say Trinidad Cement Limited and Arawak Cement Limited, could endeavor to do in the intervening break between now and the hearing is to engage in correspondence with Dr. Bab Schaefer to elucidate those areas where we might want some clarification and invite her to give that clarification. And it's only if there's a dispute on that, we might then want to ask certain questions for the court to hear and adjudicate on, but we would want to avoid the unnecessary appearance of cross-examining counsel unless it became absolutely necessary.
But if you had that exchange with her, then it would be in writing and all the parties would be privy to it.
Yes, that's my immediate thought, and I say that without having consulted with Mr. Peterson and the rest of my team. But we could, in order to avoid the quote-unquote spectacle of having Dr. Bab Schaefer in the witness box.
Yes. Dr. Bab Schaefer, is there anything you'd like to say on this issue?
Your Honor, I could only hear what you said, not my learned friend, but I have no difficulty being cross-examined.
No, well, we know that, but the issue was whether, well, what I did is I asked whether anyone will take objection to you being counsel in the matter and at the same time being cross-examined, because of course we are an international court, not a common law court, but everybody is too familiar with the common law rule that as counsel you ought not to be given evidence from the witness stand. Well, yes, but to go in the witness box and be cross-examined and then to go back at the bar table and present arguments will sort of aggravate the issue. If somebody else signs these affidavits, then the issue is one, whether that person will be able to speak with sufficient knowledge to give coherent answers in cross-examination, or the suggestion that was being made by Mr. Armour is that the parties that wanted to cross-examine you could instead ask you written questions between now and the date of the trial, and have all of that correspondence shared with all the other parties.
Yes, Your Honor, the latter option seems to be the best. In fact, there would have been no need for an affidavit, at least in relation to certain matters, if counsel had just simply contacted CARICOM.
Yeah. Okay, I'll tell you what we could do. I haven't heard a specific objection. We can go the route of anyone who wants further information that Dr. Bab Schaefer can supply to elicit that information from her by written correspondence, copying all the other parties, and at the date of the trial, on the day of the trial, if there is further information which whether the court or a party wishes to have from Dr. Bab Schaefer, then with the leave of the court, we can ask her to give that information from the bar table. Yes. Dr. Bab Schaefer, is there another person from CARICOM who can give the information that you have provided in your affidavit, and who can make himself or herself available for cross-examination?
Yes, Your Honor. I could ask the fellow attorney at law in the Office of General Counsel.
Okay. So, will that person re-swear the affidavits that you swore, or would you simply make that person available for cross-examination?
That person will swear the affidavit. The person is currently in Chile, but should be back in Guyana, in Georgetown, around the 27th of May. That person would swear the affidavit in relation to one of the matters, that is the confirmation from P.S. Peter Phillips that she attended the meeting. Perhaps fresh correspondence could be sent to her so that the person speaks directly to what they know or believe based on evidence given to them.
Okay, Ms. Tulsi?
If I might suggest, just sort of keeping matters very tidy, CARICOM has filed with Ms. Schaefer has filed more than one affidavit. We've also had certain evidence exhibited to submissions and not necessarily has come to an affidavit. Insofar as all of the parties have been required to file witness statements, and I understand that's the direction available to CARICOM as well, but I'm perhaps wondering if it might be better to just have this new person file a witness statement, tying all of the matters together, and then we move forward with cross-examination on the basis of that.
That's a sensible suggestion, I think. Did you hear that?
Very
Dr.
sensible.
Schaefer?
No, Your Honor.
Okay, the idea is that rather than we swear affidavits and all of that, the new person, the new attorney, can simply file a witness statement that embodies those affidavits that you had already sworn. And they can even do that simply by saying that I endorse or attest to the truth of what is stated in those documents without having to rehash all of it. And then that person makes himself or herself available for cross-examination. When do you think you would be able to file that witness statement?
Sometime after the 27th, so maybe around the 29th, because the attorney at law is currently on UN training in Chile and will not be able to swear the Chandra will not be able to swear the will not be able to swear the affidavit before he returns to Georgetown, or the witness statement before he returns to Georgetown. So it would have to be in the week of the 27th of May.
Okay, 29 days. Okay, so we give you until the 30th.
I'm guiding, Your Honor.
Okay, so just to rehash the orders that we made.
relevant, and they have served notice object to the evidence of Yago Castro, Jose Gonzalez, and Dr. Patrick Antoine. At paragraph 2 of that notice, they say the basis of the objection is that the witness statements contain inadmissible, irrelevant evidence and statements on the ultimate issue for the determination of the court. May I ask the court to consider giving a direction today that Rockard should identify the passages in the respective witness statements to which they will be taking objection, so that there could be a more efficient management of the submissions that will then follow on those objections. And if they could do that in writing before the 11th of June, please.
Mr. Wood?
We were taking objection to the entirety of the witness statements because we consider the matter is one of law dealing with classification, and the witness statements, as we read them, seem to be completely irrelevant to that issue.
Right. So I'm not surprised that that
has been clarified.
Response. Yes.
Thank you.
Okay. So as to the order,
and I don't think we were not the only party to take that position. I think Trinidad also took that position.
yes. And we will hear those objections in the course of your oral submissions, and they will be subsumed in our ultimate judgment. Now, the order of the oral submissions. TCL will go first. How much time do you wish, Mr. Armour?
Your Honor, I would ask for an hour.
Okay. Now, I take it that that's a consolidated submission, TCL and ARAC.
Yes, I will be making the advocacy on behalf of TCL and ARAC.
Okay. And then we will hear from the state of Trinidad and Tobago.
Ms. Tusi?
Your Honors, we an hour as well.
State of Trinidad and Tobago, 1 hour. And then the state of Barbados.
Yes, Your Honor. No more than half hour.
About 30 minutes, yes. And then Rockhard. I take it an hour.
An hour. I should say an hour.
An hour. Yeah. And then
40.
Motilal Ramit. $30 minutes, yes. And then CARICOM. Ms. Bob Schaefer, we're just wondering now the amount of time that you will take for your oral submissions on the second day.
45 minutes, Your Honor.
Okay. Oral reply, yes. Who's responding? That's the difficulty. How long are we already? 1, 2, 3, 4. What, 4 hours and 4? Yeah, who's the 4 and 5 minutes. What's going through our minds now is, because this is a consolidated hearing and the parties on both sides and so on, the issue of responses, replies. Any wonderful suggestion, Ms. Casey?
Your Honor, the difficulty is that ROCAD is a claimant in one, but TCL is a claimant in another. So strictly speaking, both are entitled to reply. If the court, the submissions fall on either side. So the implicated parties are advocating one position and the other is, for example, Trinidad is pretty much on its own and TCL is on its own in the position that they are putting forward. So I'm not sure if we can really just do it by issues if the court really invites parties to respond on certain issues, which we think
So see, that's good in theory, but no, just
I want to reply.
Mr. President and Your Honors, if I could respectfully suggest that, strictly speaking, I think the claimants, Your Honors may consider restricting the reply claimants only. At least that's the added advantage of being a claimant. So ROCAD and TCL may be the claimants to reply.
yes.
Restrict them to 15 minutes each, if I could suggest. That way we get it
Only
all
two
wrapped up.
replies, TCL and ROCAD, and 15 minutes each.
Your Honor, what I would suggest is that on the day, if the court, if we may ask legal waivers on a particular issue.
Okay. We probably better start at 9 again. Okay. Can we go late? Okay. Okay, the replies will be TCL, 15 minutes, ROCAD 15 minutes, and with the leave of the court, one or more of the other parties may be granted leave to reply. Okay, we start the second at 10, but it'll be a long day, so we may go up to 5.
May please, you have one other issue, my lord.
Yes.
Your Honor. The ROCAD witnesses are all overseas, and as before, I would ask that their cross-examination be done by video link. Mr. Maloney, Nicely, and Brooks.
Yes, they will be in, where would they be?
Mr. Maloney is in Trinidad, Barbados. Mr. Nicely and Mr. Brooks are out of the United States.
Okay, so...
And Mr. Nicely may be traveling, I'm told. So I'm not sure where he would be on the exact
I
day.
see.
Your Honors, we would have no objection to that.
Just a minute.
Yes.
Now, apart from Messrs. Maloney, Nicely, and Brooks, everybody else plans to be here in Trinidad, I take it.
Yes.
May I just say this, Your Honor? Dr. Patrick Antoine is not ordinarily resident all the while in Trinidad. We expect him to be here, but we certainly would want to reserve the possibility that he may be abroad on the day of cross-examination, and if necessary, we may have to make an application for him to be allowed to be cross-examined by video link. But that's just out of an abundance of caution.
Right. Actually, I would strongly urge that you make every effort to
yes, we
see
will.
whether he could be here in person. And in fact, Mr. Wood, we were of that same view in relation to Mrs. Maloney, Nicely, and Brooks. If every effort can be made for them to be present in person, but if they can't be, then by all means, we will take them by video link.
Yes. I strongly doubt, I would reserve Mr. Maloney because he may be able to attend, but certainly I don't think Mr. Nicely or Mr. Brooks will be able
Okay.
to travel.
Yeah, but yourself, you will be here.
Yes, it seems we'll have to be here.
Unfortunately or fortunately, Mr. Wood.
Well, let me not say I love Trinidad. May I say it would be good if council at some point could perhaps pin down a time period when Mr. Nicely or Mr. Brooks would be taken rather than having them waiting, hanging on all day.
Okay, I tell you what, in the order that we will send out of today's proceedings, we will give a rough estimate of the times when the witnesses will be cross-examined. Now, it's a rough estimate, so they need to stand by for like half an hour before the time that we slot for them. And but at least you'll get some idea, so that they wouldn't have to stand by for the whole day.
Right, and perhaps they could be interposed if necessary or whatever.
Well, exactly, that's true. Yes. Yes.
Your Honor, may I make an inquiry?
Will they be here too?
Yeah.
Mr. President?
Yes, Mr. Armour.
In the management of cross-examination of witnesses by video link, will there be any arrangements that the court will be able to supervise for the integrity of the process so that a court officer could be present at the locus of cross-examination for the normal discipline of cross-examination to be maintained?
Yeah, actually, Mr. Wood, can you remind me again, where would Mr. Nicely and Mr. Brooks be if they aren't here?
Mr. Nicely is an attorney, I believe, in Washington, but he right, and he said he would be traveling at that time. Mr. Brooks, where is Mr. Brooks? Mr. Brooks is in Colorado, but these are expert witnesses, so they are not witnesses of fact.
Yes.
So I would have thought that, you know, as in the normal treatment of experts, in some jurisdictions, they are even questioned on paper. So I would suggest that some flexibility can be given there because they are not witnesses speaking to facts in the normal manner, nor are they certainly Nicely or Books, nor are they, do they have any interest in the matter other than experts.
I would leave that for the court, certainly with respect to those two gentlemen, but my inquiry would remain certainly with respect to Mr. Maloney.
Yes, well...
in terms of the supervision of the process.
Yes, efforts will be made to get Mr. Maloney here, I gather, but if he isn't, then I take it he will be in Barbados, and he could give his evidence from the court in Barbados. But we would prefer him to be here. Yes?
Yes, Your Honor. If he is in Barbados, we're actually doing the video conferencing from our chambers because the Supreme Court, now that they've moved back, they haven't set up their video conferencing as well. But I could undertake that if it is set up, that Mr. Maloney can use the facilities at the Supreme Court complex.
Okay.
In the event he does not reach to Trinidad.
Okay.
Ms. Prophet, do you plan to be in Trinidad?
Yes, Your Honor, I plan to come to Trinidad. And I wanted to ask an additional question. When we were first doing these case management conferences, there was some mention of a reserve day on the 13th. Looking at the timetable that has now been given, should I advise my government that I should at least be there for the 13th in case there's an overspill in terms of time, or will we be finishing 12?
It's a difficult question because these are 2 very full days, which would mean that if something happens, then we would exhaust the 2 days. So I think that you should do that. You should indicate that there's a possibility that a 3rd day is going to be required. The best we could probably say to you is that I don't think we would exhaust 2.5 days. So that, if anything, we may use the morning of the 3rd day, but I can't see us going beyond that.
We would only exhaust ourselves.
Okay, so is there anything else which we haven't addressed, which Council would like us to look at? Okay, in which case, we will give you the order. I won't repeat all the times, but we would... yes,
one other matter, my lord. Yes, I can only speak for myself. I find the switching around of the multiplicity of documents filed in various actions to be difficult to manage at best. Mm-hmm. And I would suggest that we use TTOJ1 and perhaps strike a bundle if possible. That may be a bit much, but certainly to use TTOJ1.
On couriers, it took pagination.
It's very difficult to put
Yeah,
them on.
but isn't that possible for us to do?
Documents are only filed in the other matter.
We're going to try to share the travel bundle. This year.
Right. And how would that affect our courier pagination and all new documents need sequence from 1 to 10,000, whatever. You see, Mr. Wood, that's an excellent suggestion. But how are we going to make it happen? Are we going to ask one party to file maybe one trial bundle with all of the witness statements, all the oral submissions, all the authorities on the classification issue?
I'm sure that's not beyond the capacity of TCL, and I'm sure they will be willing to accommodate the court.
I'm gratified by the confidence of my learned friend Mr. Wood in TCL, but that is quite an undertaking. And I would certainly need to give it serious consideration and to consult with my colleagues on what we would be undertaking.
Is there any way of spreading the load around? Ms. Tulsi?
Your Honor, I have an alternative suggestion. Well, one observation in respect to Mr. Wood's suggestion of saying number one. I believe in the earlier before the months were consolidated. So, for example, CARICOM's filings were only filed, were not filed in number one until the later things because CARICOM is a party there. So we run the risk of excluding some documents if we only use number one. The follow-up observation to that is that, of course, I think instructing a
Right. I like the second suggestion better than the third, namely that the instructing attorneys get together and see how they can come up with a single trial bundle. Yes, Mr. Peterson.
Yes, Mr. President. Our instructing attorney just indicated that he's prepared to undertake that exercise, which we think is the better of the three. That they get together and produce one comprehensive bundle doing the cross-referencing from matters in which there would be documents missing in some, and generate one bundle and circulate that index of that bundle. And then parties could respectively pull their documents together so that the burden wouldn't be shared by one entity.
Yes.
As Mr. Hood suggested, TCM.
Okay. So, with whom would you collaborate concretely?
Our instructing attorney is Mr.
Ajoda.
Vasquez, liaised with Mr. Isi and Ramhit's
And Rockhard?
and Rockhard and CARICOM, and they could settle on a bundle.
So it would be a bundle with an index.
A bundle with an
Easy
index,
to follow.
but it will cross-reference. It wouldn't be one, because as Mr. Osi correctly said, when CARICOM came in some of the matters, they have documents in some that did not appear. So they will go through, generate an index, pull the documents, generate one, if we could call it a trial bundle for ease of reference, with an index. So when we turn up documents, we have one index we're working with, but documents from different matters. But it will not matter technically since it's consolidated.
And who will file a bundle with the court? Because the court will need a bundle, or at least one.
And the date by which this could be done? Yeah.
Your Honours, in the break, may I just indicate that the instructing attorney who would be undertaking that on behalf of TCL, ACCL will be Mr. Miguel Vasquez of the firm of M. Hammersmith and Company, not Mr. Ajodia.
I see.
I'm being urged to clarify an issue, Mr. President and Your Honours, that we file an index, and after they collaborate, they file an index identifying all the documents in that index.
But
they're
that's a suggestion.
Yes, but do we file a bundle for the court? Or we file a bundle for the court? Or do we identify the documents from the index and the court will pull those documents electronically?
What do you think, Mr. Peterson, would be the best thing so that we can, when we start the matter, we can move smoothly along, rather than having to pull this from here and pull this from there?
We could do an index and an electronic bundle.
Of course,
Yes.
I don't see how that is going to work when we're going to be cross-examining witnesses on their statements. They will need to have some document, I would have thought, before them.
No, well, each... you see, we deal with an electronic bundle, but each witness should have his or her witness statement before him or her.
Yes.
As he's cross-examined.
Yes, madam.
Now, that's a straightforward issue. We just print it off.
Yes.
So I don't think that's a
And what if you wanted to take the witness to a document that is not in the electronic system in cross-examination?
Your Your Honors, if I may intervene there, I think particularly if we are talking
Hold on,
about
Mr. Armour, just hold on a minute, yes.
Sydney.
You signed one. Okay. Yeah. Yes. This is a little bit by the way, but I'm reminded that the witness statements that have been filed, we need to get the original hard copy with the court. That has to be delivered to the court because that's the copy that we will show the witness as he or she takes the stand and is being cross-examined. So, we're going to ask instructing attorneys to be in touch with the court to make those witness statements available.
Mr. President, if I may be just allowed to make an intervention on that, because that's exactly part of the concern that I was about to articulate. For purposes of cross-examination of witnesses by video link, we need to take into consideration the fact, let's take Mr. Maloney. Let's assume Mr. Maloney is given evidence by video link from Barbados, and we are cross-examining from the seat of the court in Trinidad. We will need to have available to him on the screen not only the physical, or unless the physical witness statement can be provided to him in Barbados, but if we wanted to then cross-reference his cross-examination to other documents that have been filed, we will need to have a system in place to allow those documents to be brought up on the monitors so that his attention can be focused on those documents.
Mr. Halliard, is that yeah, but right. But if he is on a remote location, given his evidence, would he see what's on our document reader? Yeah? Okay, because in the same way that he's seeing the picture of what's happening here, he would see what's on the document reader. So that, Mr. Armour, I think we could take care of that, because whatever counsel who is here is referring to, we can place on the document reader, which will come up on the screen that he would be seeing, so that
Thank you, Your Honor.
He would also see that material. But I want to get back to the indexed trial bundle that Mr. Vasquez of TCL is going to help us with. The instructing attorneys, we said, will collaborate in the preparation of an indexed trial bundle.
Yes, ma'am.
And that will be filed by TCL on or before when?
June 7th, advise.
7th of June. Okay.
A week before.
This trial bundle will be filed in case number 1?
Yes, please, ma'am.
We would need that a little earlier than the 7th, because if we leave on about the 9th, that doesn't give us much time to print off or to collate.
The 7th is late for them.
Mr. President, we are considering if we could have done it before, but CARICOM will be bringing in documents on the 30th. That may pose a challenge, but we will aim to do it earlier in the 7th. The 7th is an outside date.
I would ask for the 5th.
Well, we have to do it, the CARICOM documents will have to be a supplemental bundle. Yeah.
How much earlier can you do, Mr.
Much earlier.
Peterson?
We'll do it on the 30th, please.
30th, okay.
And we could do CARICOM as a supplement.
CARICOM as a supplement on the 7th.
Supplement. When the CARICOM comes in early on the 30th, we may be able to include it.
But the latest would be the 7th.
The latest would
for
be
CARICOM.
for CARICOM as a supplemental.
And just one filed in the first matter.
Yes, please.
Okay. So we start at 9 a.m. on the first day. We start at 10 a.m. on the second day. CARICOM is given leave to file a fresh witness statement by the 30th of May. All the witness statements, including that CARICOM will file by the 30th of May, will stand as evidence in chief. Counsel will...
I didn't hear that.
Yes. You will file a fresh witness statement by the 30th of May. That witness statement that we said will incorporate the affidavits that you have already filed, so that the deponent of that witness statement will be available for cross-examination. Do you have that, Dr. Schaefer?
Yes, Your Honor.
And we also would like all of the witness statements, the original hard copies, to be lodged with the court. When do we want that done? Right. On the morning, yeah? At the latest on the morning of the first day. The instructing attorneys will collaborate in the preparation of an indexed trial bundle to be filed by TCL on or before the 30th of May. And it is going to be filed in case number 1. And a supplemental bundle, which will incorporate CARICOM's witness statement, will be filed on or before the 7th of June. The order in which the witnesses will take the stand: TCL's witnesses will go first, followed by the witnesses of the state of Trinidad and Tobago, followed by the witnesses of Rockhard, followed by the witnesses of Motilal Ramit, followed by CARICOM. On the second day, we will have the oral submissions, and these will follow pretty much the same order. TCL will submit, followed by Trinidad and Tobago, followed by the state of Barbados, followed by Rockhard, and then Motilal Ramit, and then CARICOM. And TCL and Rockhard will have 15 minutes to reply, and then with the leave of the court, other parties may be granted leave to reply. All of the witnesses are to be present in court, those who are to be cross-examined, save that Mr. Maloney, Mr. Nicely, Mr. Brooks may be done by video link. I think that's it. We will get this order out to you by tomorrow, hopefully, so that you will get a good idea of when each witness will be set down for cross-examination, so that you can advise them accordingly.
Your Lordships, there are
Just a minute. Let's say Ms. Dr. Schaefer. Yes?
Yes, I'm inquiring whether the attorney at law who will give the witness statement, that is O'Neill Francis, he's also counsel in this case. I would just like to confirm that he will be able to sit in court throughout the 2 days.
Yes, there's no difficulty with that. I don't think anybody would object to that, so that's not a problem at all. Yes.
Just two matters. It does not impact on the order in any way, but we wish to state it for the record. And this is for the second intervener. In terms of Rockhard's application, essentially seeking that the matter proceed on submissions and not necessarily evidence, the second intervener, Untitled Chapter, we support that application. And secondly, and the reason for supporting it, of course, is that we don't necessarily agree that the competing nature of the different cement products impacts on classification. And what that will entail, depending on how the matter goes forward, there may be objections to some of the questions posed in cross-examination if we feel they are irrelevant by whichever.
Yes, I fully understand. There's an overarching issue of whether community policy should drive classification or the other way around, whether classification should drive community policy. And that's something we would hear submissions on. And the answer to that will determine, albeit ex post facto, whether certain witness statements are or are not relevant. Is there anything else?
Not from us.
Not from us, my lord.
Oh, Your Honor.
Yeah? Mr. Wood, are you good?
Yes, ma'am. Yes, Your Honor.
Okay.
We're fine here.
Okay. All right. Thank you very much. Barbados, Ms. Braffett? You
Yes,
still
Your
with us?
Honor.
Yes? Okay.
Yes, I'm still with.
Okay. And Dr. Bab Schaefer?
Yes, Your Honor.
All right. Thank you very much. We'll see counsel on the 11th. Wait just a second.
Yeah, just let me add, because probably not all attorneys are accustomed to do their work in an international court, but just to be clear that when we talk about witnesses, the bench will also have its questions and will be more free in asking those questions than you would be accustomed in a common law environment. So just for the record, that is clear. And there will be re-examination also, of course, and during that day. That needs to be added to the first day, so I suppose that will be a very long day. And as to relevance, it is also to be known that the procedure in international law is not as strict as it may be in common law. So therefore, it is not unusual to hear witnesses and decide this after hearing them, whether there is relevance and whether they should be looked at or not. Just to be clear.
Okay, so thank you very much, counsel.
Court rise.